Hello, everyone. Thank you so much once again for joining us today on the Voices podcast. Today, we are honored. We have a special guest, we have a special voice. Today, we have Judge Harrison Mutabazi. He's, he's a judge of the High Court. You are also, you have so many other hats that you wear. And I believe so many people out there don't know all that. And I'm sure it would be an honor to hear everything that you're wearing that everyone needs to know. Who is Judge Harrison Mutabazi, and what are some of the other hats that we don't know that you might be wearing?
All right, thank you so very much, Rafat, for having me on your podcast. As you said, my name's Justice Harrison Mutabazi. I'm a judge of the High Court, first of all, of Rwanda. And secondly, I'm an inspector of courts. I also double as the incumbent president of the Rwanda Judicial Officers Association. That is a local association, an umbrella that brings together judicial officers in Rwanda. I am also the point person in implementing ADR. I'm speaking this because I know on this podcast we'll be having moments of talking on ADR that we are implementing in the courts, but also in the justice sector at length. Also talking about our association, we are also, the Rwanda Judicial Officers Association is part of the East African Magistrates and Judges Association. I've also been their Secretary General some time back when it was a rotational basis for, and then Rwanda was given that slot, so I was. So as you said, those are the many hats that I wear, but all of them definitely in for service of my nation, definitely of my sector, in the justice sector. And that way, and also just what I didn't tell you is that the Rwanda Judicial Officers Association, being a member of the East African Magistrate and Judges Association, but also we are part of the Commonwealth Magistrates and Judges Association.
You've talked about all those associations.
Yes.
My question here would be like, why are you part of so many associations? You've talked about two associations, the East African Association and the one for Commonwealth.
Yes.
What do we gain from that?
Well, definitely there's a lot that we'll gain from them. I'm now talking as judicial officers, what we gain from these associations. First of all, these associations or umbrellas bring together judicial officers that definitely serve a common purpose. So it is pertinent that we're now a global village. We're no longer working in isolation. You can see now we solely depend on ourselves. We definitely sometimes need to benchmark on each other. So these umbrellas make it very easy for us to benchmark from another judicial officer. For instance, if I needed probably a president that could probably guide us from the Philippine Islands, for instance, the Supreme Court of the Philippine Islands. It'll be very easy for me to definitely look out to my colleague that is in Manila and probably say, hey, look, I would need a judgment that was decided either on this matter that we think can guide us in one or the other, probably in this way, and it will work very easily.
What are you trying to say? Are you trying to say that, let's say, in case we have a case in Rwanda,
yes, in case
and we don't know how to go about with that case, you can refer to a case from Manila.
I'm saying, for instance, we have a case, and you've probably Googled up and you found there's a case, similar case that has some probably a little
Similar elements.
some elements that can be of guidance. It will be guiding. We won't cite it. Will depend on it. You definitely can cite it in a judgment. You've seen our judgments, some of our judgments citing cases from South Africa, from Australia, from elsewhere that can be persuasive, that can be guiding in determining a matter. So that was I was saying that you could go up and you find probably that case was ruled by the Supreme Court in Philippines. and getting it, probably having the entire judgment will be a little bit harder. So it will be very easy for you if you have a colleague that you've networked in such networks and such associations to definitely reach them out. But there are several other benefits. We usually meet annually. We usually have an AGMs. Last year we were in Arusha. We had an AGM for the East African Magistrate and Judges Association. You remember last year in September the annual conference on Commonwealth Magistrate and Judges Association.
It happened in Rwanda.
It happened in Rwanda. It was here, and it was well. It went through well, very well. It was appreciated, and there was a lot that we learned from there, because when those meetings happen, we not only come and meet and network and feel good and what, but also have moments to get topics to study and depth and analyze and exchange. And one country will tell us how they've done, and definitely there's a lot that we learn between these meetings and that. So that is why it's very pertinent, but also the visibility and all that comes with being in such networks and knowing that definitely we are also very much capable in doing this in that way is something that is so very nice. So I think it's a nice route or path that we took to decide to join these associations, and of course we are seeing the yields coming back. Yes.
The Minister of Justice has been silent for a while. You rarely go to media speaking about things.
The judiciary, the Minister of Justice.
The judiciary.
The Minister of Justice is different. It's a ministry, and the judiciary. Yes.
The judiciary.
Yes.
You rarely go out to speak about different things that you're doing or you're going through at the judiciary. But this time around, it seems like things have changed. I'm sorry to ask. Okay, I might have approached you, but. It's kind of rare. But why are you here now? If someone would ask you, why are you here? Why did you decide to come here?
Right. You're very right that the judiciary and now the courts, as you say it, very much people know that it's a place that people will go there when they have disputes. So they really, in the past, I'm saying in the past, but now it's changed, and you're right that the trend is changing. You're seeing us very much in doing a lot of outreach, especially on media and social media and all that, and everywhere. And you're right that I'm coming on the podcast and all. So, reasons being that I'll say that I'll base on our constitution. Our constitution says that we render justice in the name of the citizens, so in the name of the people of the land. So if we render justice in their name, it means they have stake in our business. So we are obliged to tell them what we are doing.
Sure.
So that is why we found that it's really, and I think in this past probably 4-5 years, you've seen us really having a vibrant outreach, that we're reaching out to the masses to tell them what we are doing, because we're doing what we're doing, we are doing it in their name. So they need to know what we do. And that is why usually every year we have the judicial launch. So whenever we have the judicial launch, you will see the Honorable Chief Justice giving an account on what we did the last year and what we plan to do the next year. So all that we're doing it because that is what we ought to do. We ought to tell the citizens what we're doing. But secondly, the other thing that we also found that it is very pertinent. And we found that mostly the masses or the citizens or people, sometimes they really don't know what is happening in the courts.
They don't know.
They don't know. Apart from someone that has come there, or journalists like you that probably follow court when there are some cases that you want to follow up, or lawyer or any other, but the rest will see buildings and they will never know what happens there. So we found that it's pertinent to try and also give back to society through teaching them or reaching out to them and tell them Hey, these are the procedures you're supposed to be following. Even before you come to court, probably these are some things they're supposed to be knowing to please probably be on the right side of the law. Because, as you know, there's an old adage that says ignorance of the law is no defense.
Definitely.
Ignorance
That's
of the
what
law
you
is
people
no
say.
defense. Of course, that is what we usually
that's you
say,
say.
and that is what is.
And that's the truth of
and
it.
that is the truth. Whenever you come to the court, you can never plead.
I didn't
and
know
say,
that.
I didn't know. I didn't. So I didn't know that. So that's why we find it that is also an obligation that we should.
That thing has really touched me.
Yeah.
Let me tell you seriously. You find that most of us, even the so-called elites or the educated ones, they know nothing about the law. They don't know all these things. They don't know what happens there. They don't know how they can save themselves in case they go into trouble. So, sincerely speaking, to me, I think you're doing a great job.
Yes.
And I don't know how far you want to take this.
We want to take it further. If possible, well, we can do this by our own, or we will not do it because we're joining hands with other stakeholders that have that mandate. We know there are several stakeholders that have that mandate that are probably streamlined in their mandate to educate the masses about the laws and all that. But also us, wherever we can, wherever they will, you could reach out to us whenever we have means and time and all that. We will do it because we find it's also part of obligation to try and let the citizens know, especially the basic laws that they're supposed to be knowing, the do's and don'ts and all that. And probably it will be one of the ways that we can keep most people coming to court. We don't want a lot of people to be coming to court actually. So if we would have very many keep away from disputes that bring them to court, we will be very happy. We'll be having the few that definitely can do away without coming to court and solve that, and then the rest are done that way. And by the way, that is why you see, I know today we are going to very much be talking about ADR. That is why we're encouraging alternative dispute resolution. Now that is what they call alternative.
That's my topic of today.
Yes.
And if you're done, I wanted us to drive into that.
Yes.
Sincerely, of recent, I've seen this growing. Everyone is talking about ADR. And of course, I've seen that so many people have got to know what is ADR. But of course, there are so many people who even don't know about that.
ADR, yes.
So, what does Rwanda seek or, want to gain from, want to achieve? Because we've seen you are promoting, there's an increased promotion of the ADR, alternative dispute resolution.
Yes,
with mechanisms like the Court Annexed Mediation and Plea Bargaining.
Plea Bargaining, yes.
Can you educate us about ADR and of course these mechanisms? How do they work?
Thank you very much. Actually, first of all, I would want to thank you that, as I said, we can never have moments to every time have people to reach out to them. But when we have moments like this to come to a podcast like this, to go to radio stations, and newspapers, that helps us to reach out to very many. As I said, there's very many that are out there that only know that the courts, the only business that is there is judging.
Definitely,
Yes,
that's what people think about it.
Yeah, they just hear courts, and when you relate with the court, it's only judging. You go, you plead the case, then the judge will listen to the two parties, and then go back to their chambers and decide over, and then rule over, and either they convict you and sentence you, and that is it. And so that is what people don't know very soon with the courts. But it's good, as I said, whenever we have a platform, whenever I have a platform like this to come and talk about ADR, I get very happy because I know I'm very much reaching out to at least very many people that probably will never come to court and have a moment to sit and listen to us talking about ADR. But wherever they will see this podcast, they will know there's another method that you can resolve their dispute other than reaching out or going through litigation. Actually, there are two terms that we usually use. There's litigation, and then there's ADR.
You are saying that you're talking about
Yes,
why ADR is...
I was talking about ADR, and I was talking about the two terms that we use predominantly. The first one is litigation, and litigation is the mainstream or the classical way of resolving disputes. That is going through the classical process of lodging filing a case in the court, and then they'll give it a number, and they'll either give you a date for pre-trial, that is a civil case, and then after pre-trial you will come before a judge, and judge will listen to your submissions, and then the judge will retire to their chambers, and then will pronounce the judgment, and you win or lose. That is the classic way that most people really they know. But of recent, ADR has now also taken very much shape, and has taken and is gaining momentum in the courts, not only in our Rwandan courts, but it's worldwide. And reasons being that there's a lot. I will be talking about the benefits, but I'll begin by establishing why ADR is now taking up the better part of the processes in dispensing justice. As we say it, we call it alternative dispute resolution. But most people now are coming up with another definition. They're calling it appropriate appropriate dispute resolution. And others, especially in Africa, they're going further and they're calling it African dispute resolution.
Actually, so, if you bring me to that,
yes,
I really would agree with that one. Yes. African dispute resolution. Because this is how we used to do it. This is how even in communities people used to long ago, even our grands and grands, they used to sit together. Long ago people used to live in extended families.
Yes.
You find that people living 10 families are living together.
Yes.
And when there is a case, they would bring the order of the oldest of the family and sit them down and tell them, A, B, C, D. So now you are guilty, you are what? Innocent. So I think this is an African style.
Oh, very much so. By the way, I was in a network, and now we have an African network forum of chief justices that have come up to make a network on ADR. So I was one of the networks. They were launching this network in Kampala early last year. And that's what they were arguing. They're saying this should be African dispute resolution network.
Sure.
Because as we said, this is homegrown. Though it was taken now, it's taught in big universities abroad and everywhere.
And they've given it a professional way of handling
very
it.
Much so. And they come back here and then they sell it to us, and then they say, now we're teaching you and give you an LLM or a PhD in ADR. But it was here. You talk about Gachacha.
Talk about Gachacha.
Gachacha, not only the recent one. Even long ago, there was Gachacha. Yes, there was Gachacha, and that is
the
why...
grands used to sit down, families and...
Kumuchacha.
Yes, Kumuchacha.
That is why it's called Gachacha. So that is ours.
For someone listening, Kumuchacha, it's a type of grass that, that in our culture, people know it. Kumuchacha, they know it.
Very much so. And we used to have our kuru muryango, or heads of families, that before a dispute could go out and go to anywhere, they would first resolve this. And by the way, that's why there was very minimal disputes that would go to classical justice in that way. They were all resolved first in those clusters, in those circles. And then after, that is when, if they've resolved, and that's when they would go out and then probably go to the chiefs and then up to the king in that way, in that structure. So we had our justice, and it was doing very well, wasn't it?
It was doing well.
It was doing very well. So, and that's why now it's coming back. And it's coming back, I would say,
I feel bad that it's the whites that have brought it back.
No, but definitely it's good that...
it's good, but of course, it's not us who have brought it back. There's so many things that we can still look at and say, you know what, we need this one back before even someone else finds it. But
putting aside that, that is why we are now trying to see, because with the issue of backlogs that are definitely in the courts, with the issue, and as you know, an old adage that says justice delayed is justice denied. But again, on the other flip side, it says justice hurried is justice buried. So now these are two phenomena that is we in the courts are need
justice
to
hurried
is justice buried, and justice
delayed is
justice denied. So these are two phenomenons that we in the justice sector, in the judiciary, are supposed to be playing between the two. You're supposed not to delay justice, and because you'll have denied it, but you're not going to hurry it up that you may bury it up. You see? So you cut across between on how you're supposed to do, because at the end, what you need to serve is justice.
Pure justice.
Pure justice. So that is why we've said we will not only stick to litigation. It has worked. It works, definitely. It does justice. But we will not say it will stick this, because we are seeing how it goes. It definitely, there's another way that we do. Now, that is how ADR has come in. And Rwanda, of course, as a country, for us, giving the history we've been talking about, but also seeing what Gacaca did. That did a lot of good stuff that helped to bring justice to the country, and definitely people coming over to learn justice, to learn about Gacaca. When we go to those forums, I'm part of the forums that talk about ADR. Whenever I go to talk about ADR, especially mediation and plea bargaining, the other aspect they tell me talk about is Gacaca. There are several countries that have modeled their ADR, what they call the alternative justice systems, from the model of Gacaca. So it shows you how really we have something that of value that has now valued internationally.
Sincerely, to me, Gacaca, I consider it the number one homegrown solution that we've come up with. To me, that's what I consider it. We have so many that we've really come up with, but to me, still Gacaca stands out for me as number one.
Yes,
because I'm sure you people, you would have never managed to crack down all these cases.
Definitely, it's on record, So I was saying that we've learned from Gacaca, and then after Gacaca, we had the Abunzi. Abunzi,
the community mediators. Community
mediators. To those that don't know, probably our local dialect, Abunzi is kunga, it's mending, definitely. So it means they're there to mend relations that have broken, or people that have gone into disputes, and really they're falling apart, and Abunzi trying to mend them. So we've seen Abunzi doing tremendously very well. They've helped the classic courts. If the Abunzi were not there, I really don't know how the backlogs now will be swelling. There will be so many. So they did tremendously well. So after that, when we saw how the Abunzi have done very well, how Gacaca has done well, so we said, why now can mediation be introduced in the courts itself? You see. So it was unheard of, because it was the first time to hear that there's mediation in the court. Else, no one had ever in the history of
heard of that.
No one had ever heard of that in the history of Rwanda, that there's mediation done in the court. It could be done by court, because whenever you go to court, everyone will be anticipating that they're going to go before a judge and then decide on. So in 2012, that is when I would say that there was a kickstart of mediation. And so when mediation is done in court, that is when we call it Court Annexed Mediation, because it's a mediation that is done on cases that have already been lodged into the court, in the court dockets. So that is how we started.
Oh,
yes.
So let's say I've lodged a case in court, and then during the process, pre-trial and trial, are those cases that have already reached trials?
Well, thank you so much. How it started in 2012. By the way, it came in when we were beginning our pre-trial hearings. Before, we didn't have a phase called pre-trial in our system. It wasn't there. It was first introduced in the civil procedure of 2012. That is when they brought in the phase of pretrial. So when they brought in the phase of pretrial, that is when they also introduced mediation. At the first level, they introduced mediation and gave the powers to a registrar, because the registrar is the one that usually conducts a pretrial here in our system. So they say to the registrar, when you're conducting pretrial hearings, why don't you ask the litigants to try also mediation? And it started first time, and they tried it, and we were seeing things working. People were coming before and pretrial. During the pretrial phase is when you do, it's kind of you're managing your case. You say you agree on the date of the hearing. You exchange evidences. You agree on witnesses or other evidences that you'll be using. So these are things you're trying to.
It's like
preparation of the main hearing. So that is the phase that is called pretrial. So during the phase, they included in mediation. That's how it started. That's how it came into, and that's how Court Annexed Mediation was born into the court. So it worked, and we were seeing numbers coming in. People were getting mediated, especially in the civil matters, and they said, "Oh, really? This can work." And 2018, our civil procedural code again was revised, and now this time they extended the phase not only in the pretrial phase, but also in the hearing. Now you see how it's coming in? Now they gave the powers to the judges, and registrar, of course, but also the judges. They say the judge, even when you're before a litigant and you're going to hear the case, you can begin by asking them, I see you guys coming before me. You want me to preside over your case and hear and then make a decision, but can't you try mediation? When they say yes, they can even opt to own to you as a judge who is presiding over.
Oh, wow.
Yes, and it happens.
This is wonderful. I mean,
happens
let me
time.
tell you,
Yes,
people
yes,
fear that person.
Yes, very much.
People
so.
fear the judge.
I know.
Looking at the judge, knowing
in the
that
gowns and all that.
knowing that he's going to decide over you, whether you go to prison or whether you go back home. Because I'm using these words to make it easy for someone listening.
Yeah, to understand us.
It is really, really something very, very relieving to hear that the same person is one who can maybe mediate you.
Very much so. Very much so.
Mediate you.
Very much so.
Are you trying to say that now, if you're the judge who is going to decide over me, I can tell you now, since you've brought this thing of mediation or negotiation, can you be the one standing between us?
Very much so. And it has happened a lot of times. Actually, the statistics I'll be telling you, you'd find almost 80% were mediated by judges, especially in the commercial courts by judges. So the litigants will say, you see, we are before you. We don't want anyone else to now mediate us. Do that. And what they do is, now this time, because you're in a gown and what did you retire in your chambers? You remove the gowns and you can bring them into your chambers. And now you sit like we're seated together like this on a round table and now begin the process of mediation. So, and all that starts that way. So that is the beauty of our process.
But sincerely speaking,
yes.
Let me ask, a lay person in this question.
Yes.
Doesn't this bring in choosing sides?
You mean judge choosing sides or anything? No.
How would you avoid that?
Well, the first thing is
because now why I'm asking this,
yes,
in ADR there's no appealing.
Of course,
you can't appeal.
Of course.
And then I don't know how you actually also enforce the agreements that have been decided.
I definitely will tell you how I will do that. Yes. So first of all, before this came into fruition and all that we're doing, actually we were lucky that we had some partners that we've partnered with that are very well versed with mediation that have helped us do a lot of trainings to our judicial officers. So, and that's why you see we've gone to this far. We have partners from the United States called the Edwards Mediation Academy. They've been here for very many years, so they've graciously helped us in training judicial officers. So ADR, but also mediation, it's an art.
Yeah,
it's an art.
It's an art for sure.
Yes, so you need to train the person that will be doing mediation on how you're supposed to handle the parties on how even the ethics that you're supposed to be having through the process of mediation. You're not supposed to be taking sides. You're a facilitator. You're neutral. By the way, they're called neutrals. Mediators are usually called neutrals, that you don't want to take any side.
You let the parties decide for themselves.
Definitely.
You don't choose which one to decide.
And that is the beauty of mediation. You only facilitate them to reach towards an agreed agreement of their own. So that is what you do. So most of the judges now and the registrars at least have the basics. They've been trained with the basics of mediation. So in one way or the other, they will know that if I remove my robe as a judge and now retire my chambers and begin mediation, I should not take sides in one way or the other. And I should help that a settlement agreement, we call it a settlement agreement, should be well written, well drafted. And then after that, when it's drafted and well written, now you were asking how will it be enforced. They bring it into the court, and then the court will assent on it. And when it's assented on it, it becomes almost a court judgment, and then it can be executed. Here we will have an execution formula assented on it, and then if you don't execute it willingly, then it can be executed forcefully as other judgments are done. Period. In that way. So, but in all, the beauty of mediation is that the resistance that we usually see in enforcing judgments is very minimal.
Because they're the ones who have decided.
Perfect. You're grasping the skills very, very fast.
Okay,
because this is coming from them. It's their will. Actually, we've seen scenarios where people, they're on the spot. They say, okay, we are fighting over 5 million, and we've decided that I give you the 4 million, and then you leave everything. There and then, and they sign a check. Period. It's over. You see?
That's how it goes.
It goes. I'll give an experience today, and actually, I think it's a God said that it came that I was coming on this podcast. Today, in one of the courts here, there's a case that has made me very happy that settled. It had 500 parties. 500 parties. Litigants.
Give us that case, please.
Because mediation is private until I get the consent from the litigants themselves. Because that is one of the benefits of mediation. Mediation is private.
Imagine a case that is like that one and tell us how it went.
Just tell you the numbers.
500?
500. But can you a case that has 500 litigants, today it's settled
through mediation.
And
that's
the parties went back home very happy.
That's news.
And the experience I have, I've been in this profession, and I'm coming to 23 years in this profession. I know the span of the cases, the way they delay. Now, this case that has 500 litigants, it will end in the courts, probably either in the Court of Appeal or even the Supreme Court for other reviews that happen in that way, not lesser than 5 years. Can you believe that? 5 years. And that one, because it has 500 litigants, you would find it is having other files that are coming from, that emanating from the same case, several of them. That is how
so you would keep rotating on yourself.
Very much. Others coming in, others, all that happening that way. So you're seeing the beauty of mediation. 500, can you believe 500 litigants? That's a very big number. Even if there are only 10, it is sweat to handle such a file. But imagine 500. And it settles. So it shows you the beauty and the power of mediation. But the best of all, the person that mediated this was giving testimony, saying these people went back home happy. They went back home happy. They woken up very early in the morning, around 4, and they were coming from very far, and they were coming to come and for all the pre-trial hearing, and then they settled through mediation. So it shows you.
Imagine handling all those people.
You see, it'll be hassle. So
that is
so I was taking you through a journey of why mediation was introduced in the courts. Now, these are some of the benefits. So that is how it was introduced, and a lot has been done.
So now
around
people
this.
have really understood about the court annexed mediation. But now tell us about pre-bargaining.
Plea bargaining.
How is pre-bargaining? Because there's two mechanisms probably that you're using.
Well, on what I was talking about court annexed mediation. Now, court annexed mediation, before I leave that, I need people to know that it's around civil, administrative, labor, and commercial cases. That is where we have.
So you mean there are cases that cannot go into mediation?
Yeah,
like
in the court, yes.
Now, cases like?
Up to now, criminal cases cannot be mediated in the court.
Okay.
So now that's where we'll be coming to plea bargaining. So criminal cases are not brought into mediation. So mediation is solely on what we call civil disputes.
Civil disputes,
but mainly labor, administrative, commercial, and civil matters. Those are the ones that we're doing mediation in the court today. So that is why you will not find criminal matters like theft, like robbery, like whatever, going through mediation. So some other thing that happened that we're doing around to try and emphasize, people need to know what we do. We also have, apart from being done, that we have a structure that oversees mediation. We have an advisory committee that is headed by the former Chief Justice, Professor Sam Rujeje. He's the chairperson and is doing a lot around mediation. So this committee oversees on how mediation is implemented in the court, how it's done, and all that. So, and that is why I think it's
and give
now
advice around
and give advice around that. Yes. So also, before I leave mediation, probably I'll be coming back to that. But I just want to let you know that last judicial year, we had 2,199 cases. 2,199 cases that were resolved through mediation. That was
just last year.
2024. 2024.
This is a big number.
This is a big number.
All over the country.
That's the entire country. This year alone, we haven't concluded our judicial year, but we have now 2,759 cases to today.
Wow.
To date.
Since January.
Yeah, since our judicial year started. Well, our judicial year will be end this month, and we are looking to that we're going to be having 3,000 cases resolved.
You're likely to have 3,000 cases.
They will. We're very sure they're going to be. In these cases, and these are not small claims cases. No, some people will be thinking these are cases that are involving 1 million, 2 million. No. We have. I will give you an example of one case that I know. The amount that they're disputing over was 5 billion. That was one case.
5 billion
Rwandan francs.
And that case was resolved through
mediation. And
one
settled.
party said, okay,
yes,
now
very much, and they agreed on how they can reduce the amount and the interest and the payment and all that, and resolved. And others in billions, in American dollars, especially in the commercial.
That's a great achievement.
Very much so. In the commercial matters, there's a lot of money that if it would be taking only litigation, it would take a lot of years, because the person will appeal to the last. And then even executing this judgment that involves a lot of that money, sometimes it
influences a lot of things.
Sometimes it's amount, because you'll find that person will not want to execute the judgment willingly, so you begin looking for property to attach and do it, and again there will be some more disputes that arise through execution and all that, and you see
that's something that would take about 5 years,
even more. I've seen cases that have been in the court for because of several 10 years. End of a case that someone started, a family started, and the parents died. And then now the children that inherited the parents are the ones that were following it up. Years and years. And you find someone is embittered, at the end he gets the judgment, but again he finds nothing to attach to,
But
yes,
to a
sir.
lay person
Yes.
who doesn't know how these things go, if a case goes like that, can't you make a decision over it? Can the judiciary make a decision over a case that has lagged a lot?
And that is why probably sometime next podcast will come to probably educate the masses around procedures and how procedures work. The judiciary follows procedures. Actually, we say judicial officers are servants of the law. We can never overlap the law. When the law says this person they have the right to appeal, you're supposed to give them the due to appeal, and they will extinguish all their legal remedies that they have until they. So you can never say, well, we are tired of your case, we are throwing it out. No way. When they still have all the procedures, or they have their legal redress that is still they're supposed to follow in that way, and they're supposed to rule out all the cases that are through the court dockets. There's no way you can strike them out that way and do that way. So that is justice. It is slow, but definitely it will reach that way. So that is why sometimes people will wonder, why are the backlogs there? But it's because of the procedures that we're supposed to follow and to adhere to, so that justice should be done in that sense. So there's no any other way we can definitely, and that is why these other alternative dispute resolutions, I would say they're very much of help, because they will ease these other processes. Because in ADR,
for them, they don't follow
they don't
many
follow,
processes. It's just a matter of coming together and then decide on what
it's
to
done,
do.
and then tomorrow and there, everything is done.
An agreement is designed and then enforced.
Of course, and then it's done that way. So that is where it's coming to. But if you follow that, definitely it's supposed to be that in that process.
So talk about plea bargaining. How does it go, and what is it? What does it help really?
Right. So plea bargaining. Actually, it's an English. There are two English words in the combined. It's plea and then bargaining. So plea is to plead or to accept or to. It's almost like confessing in one way or the other. So it's plea and bargaining. Then bargaining, it's haggling. So there are two words that have been joined. Plea, bargaining. So this is a process that is introduced in our system. It's mainly a common law system, a common law phenomenon, but was borrowed and brought into our civil law. We are predominantly a civil law system. Our country was mainly a civil law system, but we've moved since we're no longer purely civil, and we're not purely common law. So we are a hybrid system. Means that we have our civil law system. We've borrowed some common law phenomenons, even our traditional law involved gachacha, abunzi. This is traditional and all this. So when we bring them together, we make a hybrid. So these are some of the phenomenons that we think. So we look at something that we feel, or a process or a mechanism that we feel would be of benefit to the country, that could help in dispensing justice, giving justice to the citizens, and we have it incorporated, and can discard the other that we feel is not of very much use in one way or the other. So that is how plea bargaining was introduced in our criminal procedural law. So how it's instituted or it starts is that the prosecutor and the accused, now the accused is when you've done any crime that you probably could be theft, could be any other. So and then you apprehended, of course, and then the investigation, run investigation bureau will definitely open up a file, and then the file definitely will be sent to the prosecution. So the prosecution can look at the file and say, well, if you plead guilty and confess and probably tell us more information, most probably in that way, and tell us other people that you really were in the same ring that we are committing the offense and all that, what we will do is, when we take you to the court, we will ask for a lesser sentence in replace for a sentence that you should have taken. Means that if you were supposed to be probably sentenced to 5 years, but because you pleaded guilty, you've helped yes in the
in finding co-accused one.
Yeah, the co-accused. You've helped the prosecution and all that to get more information. Can also, not even the co-accused, even some others that probably are still at large, that are still involved in that business, and that is credible information you've given to them. And so in exchange, they will go to the court and say, this person has been very cooperative, he's helped us, he's done this and this. Then we ask that instead of being sentenced for 5 years, just give him probably a year in that sense. And that a year, all they were supposed to be probably, we are to convict him for, we are asking that he could be convicted for two crimes. For instance, probably theft and drug. And so they say we're dropping one, and then we're only going for keeping one, and then this one, it goes for this, and then you can reduce it for 1 year or 2 years, or even suspend it in that way, depending on that. And then you will definitely make an agreement. So that is called a plea bargaining agreement. So you sign it, you, the accused, and then the prosecutor, and then you'll take it before the judge, and then the judge will look through, and then we'll see if really what you're doing is in the margins of the law, because what the law says, and there are cases that cannot go below a threshold, a particular threshold in the sentencing and all that. All finds there's something that is probably fishy, and
is the prosecutor the one who decides on the reduced sentence?
They make a suggestion. It's a deal you bargain, by the way.
It's a deal.
It's a deal between you, the accused, and then the prosecutor. That's why we say it's also in the form of ADR, because now it's a process where you're negotiating. That is why it's called plea bargaining. You know, bargaining is like when you go and you bargain on something.
How do you get the trust? How do you gain the trust that perhaps the prosecutor will really adhere to what you've agreed to?
All right. That is why I said whatever you've agreed on, you reduce it into writing. Now you reduce it into an agreement, and all of you will sign. You and then the prosecutor. In most of these cases, at least they have a lawyer who is on the side of the accused, a defense lawyer who will be also there to assist you as an accused and say, well, at least you do this, is help you in the
But that happens before someone commits to tell all the information.
Well, it happens mostly when you've given information, because it's a deal you're doing together between the prosecutor and you, the accused. Oh. So mostly it's when you've given out
you've done your role.
Your role, okay. But also not only the information, but also even that person that
accepting that you committed a crime.
Yes, has eased the entire process of the justice chain that will be there from the investigation, prosecution, the court, and you know, he said, I don't want to take you through all that labor. I plead guilty. I really did this. I did this way. And pleads guilty. So instead of going through the mainstream litigation, now you'll take through this into plea bargaining. So the phase that comes is going to the court. You go to the court, and then the court will look into the agreement, because now it's the third eye of the court that is coming in to try and look at the court and the agreement and try to see if it really was done in the realms of the law. You see? So the judge will say, all right, that is fine. I'll also
Because
assent on
the
this.
prosecutor cannot become the overall.
No. This is a deal you're making, but it's supposed to be assented on, to be affirmed by the court. But this is very flexible. In plea bargaining, you can even discuss with the judge, and the judge will say, this is not very fair, or this is, go back and renegotiate and re-amend your agreements. Go back and change this until they see justice is served. But again, there's not the rigidity of litigation. So that is why we see it serves a lot of purposes.
But plea bargaining is relatively new in Rwanda.
Of course.
And I'm wondering how many cases that so far you have.
Yes.
Since, actually, when did it start?
It was rolled out, we started rolling it out in 2023. 2023. It's relatively new. It's not very old in our process. But since then, up to date, we have 20,400 and probably 70 something cases. 20,000. And 470. We're heading to almost coming to. We're planning that probably almost at the end of July we should be going almost to 30,000 cases that have gone through. Plea bargaining, and we are going further in that way. It's really going very fast.
I can feel like really plea bargaining is working more than even.
Yes, the reasons why plea bargaining is working. Yes, we have a bigger percentage of cases than in the courts that are mainly. They're mainly criminal. There's a lot of criminal cases.
We have so many criminal cases in Rwanda.
A lot, almost 70% of the number is criminal cases.
Almost 70%.
Yes, 70% is criminal cases. That tells you that you'll find most of the courts and most of the have a lot of cases around that in that way.
And the solution would allow
definitely will allow that to happen. The civil cases are also not very few, but not so. But mediation, it's suggestive, but here you'll find that. Especially because we have a lot of people that go through this criminal process and they do plead guilty. So it's very easy for them again to definitely go through plea bargaining because they really understand the reasons why they're in that way. When a person has started following up and is in that, he will definitely know that I committed a crime and I think I need. And by the way, the beauty of plea bargaining is that there's a session to try and also educate the accused and tell them, you see, you're going through plea bargaining. This is a chance that you're going through. If you reoffend, means you recommit this crime again. This time you'll have double penalties.
Tell us about that.
Yes.
If someone goes through pre-bargaining.
Yes, especially when they suspend their case.
And
they have suspended their sentences. We've seen these cases and you find they suspended them already 3 or 4 years and they were suspended and he goes and does that.
But I think a suspended case is a case that is not negotiated about. Maybe you...
No. You can go through plea bargaining and negotiate, and then
at the end you end up not going even to serve any year.
Yeah, they suspend your case, your sentence. If it would be supposed to be 3 years, probably, or 3 or 2 years, they'll suspend the 2 years and you're out. But if you recommit that crime in the 2 years, then they will take you in and then
what if
they'll sentence you and even you serve the same sentence you had not completed.
What if it's a different crime?
Yes. Again, you see that again you're going to be convicted and then sentenced to that, you see. So what I'm saying is that we give them a session to try and
understand
the consequences. But again, you'll find that most of them will really tell that we're really touched that we've gotten a big chance to come out this way through this process. And we've seen several of them going to be ambassadors that go and teach others that they know that they're going through these crimes to probably stop going through this. So it's a double advantage that it's also a session to try and reach out to people because, in sessions like court hearings, you cannot have a session to go and teach an accused and tell them, no. It's only they come, they go
and
into...
you said it. It's procedure.
It's procedure.
It's a procedure,
Yes, you're either convicted or acquitted, or that is the business that is in there. But it's here, there's a session at least to try and reach out to them in that they will, first of all, understand what they did, how they committed a crime to society, and tell them, going back to society, be ready to be good citizens, be ready to be ambassadors to tell others what you went through and try to teach them or to be an ambassador of trying to people to keep away from crimes and all that. And some are doing this, by the way. They're doing this.
Back in communities.
Back in communities where they've gone after serving their sentence. Because plea bargaining doesn't, it's you are sentenced, of course. It doesn't mean that you're taken out. You're sentenced, but a lighter sentence probably. A more lighter sentence if you could be...
And sometimes if it's suspended, it does not mean that it's off.
No. No, even they may suspend half of it. They may suspend 2 years, and the other 2 years are served in the correction service facility. So that is how it is. But it's something that the accused or the offender will also have part in the process of restoration, in the process of knowing that he really committed this. Because sometimes you'll find someone is sentenced and it's just 2 years and you say, okay, I'll go serve and then get out. But this at least is the moment of trying to read them out and teach them how really crimes, the crime they went through is bad, and let them know that they can be part of reaching out to the society, to the rest that they know they were committing crimes together. So I think it's good. But also the other aspect that is very important in plea bargaining is also the victims and offender mediation. It also happening in these sessions. So we've seen some sessions where the victim and the offender have been mediated especially by the prosecutor.
Like which cases?
Give
an example. Theft.
For instance, there's a case, and this was a case that touched us. There are three, but one was in town here. Someone had forged and eventually robbed of another person 100 million from the account. And then already there's a lot of money that happened. Even 150 million. There are cases that we knew they had. But when they went through that process, that person pleaded guilty and said, I did commit this, and I really apologize since I've gone through this process and I've given a second chance. I was supposed to be sentenced to such and such years in jail, but because of that, I accept and I'm bringing back the money. And he said, I get access to my check, and he signed the 100 million, and they were brought back to the victim. You see, so that is also another process that you see that it also brings back a restoration.
And this one was left to go.
Of course,
immediately after that.
He was sentenced, but I think the sentence was the sentence was suspended. If I recall, it was suspended in that way. Wow. So at least also that brings back the restorative justice that we are trying to bring back between the victim and the offender in one way or the other.
Now this brings me to this question that who decides to have the mediation? Is it the two parties, are they supposed to have met and decide that now, you know what, let's do this and this? Because sometimes I might be wanting to negotiate, but the other party is not interested. How do you engage into that?
In plea bargaining, it's the prosecutor that usually do the initiation. The prosecutor will reach out to the victim and say, hey, there's a case here, and the offender, the accused that is in your case, that is pleading guilty and has gone through plea bargaining, and wants even to restitute back and try to see how they can do some restitution on the offense he committed onto you.
What if the victim refuses?
Or when the victim refuses, the law says if the victim refuses, that is their own will.
They should go through the procedure.
He could go through the procedure of probably filing for civil damages and all that way. But plea bargaining itself, it can't be hampered by the refusal of the accused. What they do is they will let you know and they will tell you, but if you say me, I don't want, the people that, well, what they want is they only want the accused only to be sentenced and sent into jail and punished in that way. And
that's
it ends
mostly
there.
what people
So that
want.
is what people will want in that way. But plea bargaining in that way said the non-sentence or the accused, when the accused says, I don't want a plea bargaining, it can't stop plea bargaining that way. The prosecutor will analyze and really say, is it beneficial? Can we proceed with it? If he says, okay, they say you will follow up your rights after. The victim has their all rights. They can follow up their case after plea bargaining has done. They can take the agreement to the court and say, yes, this person was convicted of this, and so I want to sue for damages of my property or anything or something in that way, apart from that. Yeah, but in some cases you'll find victims saying, well, even also if this person has confessed and is coming back to to normality, that is it, and I don't want anything. I want the restitute me and things, and that is it. So they happen. So it's double benefit,
So that these mechanisms are really working. Looking at the numbers you've just shared with us,
yes,
we are seeing progress. There's
a lot of progress that is coming up.
I just wanted to ask you about, these came mostly to also reduce on the case backlogs, and of today we still see some case backlogs. Case backlogs are still there.
Of course.
You a bit talked about it, but I want you to explain to us more. What are other things are you doing to reduce the case backlogs?
Yes,
because I know it's really hard on you, and it's visible. We can see.
Of course. Well, it's not only the ADR mechanisms that we are doing that we're trying to probably curb the backlogs that are in the courts. There's a lot that is being done in that. Have you heard about? There's a recruitment of contractual judges. Now these are, I would say, judges that are working on and registrars that are working on contracts, especially in the primary courts. So these have been recruited for some time, and they're really serving well. They're doing well because they've really helped a lot.
How do they work? Do they use the same?
Yeah, very much so. They're all judges. They're registrars, but they're working on a contractual basis. They're all theirs. It's on a contract. Yeah, they probably serve for a year or 6 months or a year between that, and then
to handle more cases.
To handle these cases. And then when their contract ends, or they can renew or something, and so that is one.
Also including the e-court system that is also helping.
They're also coming to that. Apart from the contractual judges, we also have we've introduced the use of IT in the business of the courts, and one of the reasons we've introduced the usage of IT is to try and very much expedite work in one way or the other. The reasons being that before you would find probably we're almost coming to 9 or 10 or something the hour of the night. No one will be in office by now. But because now everything is online, the judges or registrars will have their laptops and can work even after office hours on on the files, on airword, whenever they've rested, and then they can say, now I can have a moment when I'm home and begin working on that, or during the weekend, because everything is online. So that also is helping the output that is coming in, because if we didn't have online and we're still using the files, it would be, I wouldn't say it would be easy for us.
Wouldn't be easy.
It will be very hard. So the backlogs that we have here will have still be skyrocketing. But as you see, we've tackled this. Most of the attribution is to the usage of IT in our work.
So there's I was speaking to some people when I was preparing to have this conversation. And a friend of mine who is also a professional told me that he's a lawyer. He told me that there's this growing perception where so many lawyers and some judges are not happy about ADR. And I was like, come on. Why would such people not be happy about ADR? Yet it is coming to actually save them time and save them, a lot of energy. And you know what? He was telling me, it is... Some have considered it as something taking away their jobs, something taking away their bread. And I wanted you to clear this. Is this happening, and how are you fighting it?
Well, I would think that was a misconception of probably, well, for judges, it couldn't, because for them it's... actually, it's easing their work, because if a lot is done through mediation, then the number, definitely the number of cases that will be going through the dockets or coming to their tables will be reduced. But there was a perception probably, and I think the lawyers who would have that perception, I think it was in the old when it was beginning, but for now they're learning that it's not that way, where they thought that ADR or mediation in that sense, or any other form of ADR, could be conciliation, could be mediation, would come and probably clear away the cases, and then their livelihood, because they live on and they get fees from the number of cases that will go to bleed in the court and all that, and probably they'll be reducing. But that was not, because they found that actually, even in mediation, what I didn't tell you is that we also have private mediators. Mediation, though it's done mainly in the courts by judges and registrars, but also have private mediators who are trained mediators, because mediation entails training. And after training, and
let's say I trained, but I'm not a lawyer. I didn't study law.
Actually, mediation doesn't need that you studied law. You as in a profession that you have your background, you can do a course in mediation, and then you apply to go on the role, because now we have a role of private mediators on the website of the judiciary. If you accessed it, you'll find the names of the private mediators. You'll find their engineers, you'll find their accountants, you'll find their past clergymen, you'll find their all professionals that are because actually mediation is well done with a person that has the knowledge in that dispute. That is, if it's a dispute on probably construction, for instance,
you would need an engineer who has mediation skills.
Very much so. So on the panel, if it's a panel of 3 mediators, at least it'd be good to have an engineer
who understands that
very much,
field.
Who will be speaking a language that these people understand. Yes, than a lawyer who's going to be mediating construction disputes in that way. So you see how it makes sense. But what I wanted to say, or to demystify the perception that is out here that probably mediation will take away the market, or it's not good in that way. It's not. If it's serving, and those that have joined that, they are really getting a living in it. And definitely we look forward that even in years to come, definitely it will now be professionalized, that people can go through mediation even before coming to court. and then they can be paying the mediators that are mediating them, and then they continue like they're getting fees for consultancy, fees for playing in the court and all that. Similarly, fees for mediation also can be in that way. So it's not in any way a threat. Actually, it's another avenue, I would say, for people to look through for but mainly we will target giving justice, not
for the
business.
legal professionals. For the legal professionals who have not yet really grasped or understood this shift, who are still considering it as a loss, what would you tell someone who's going to listen to this podcast, who is a lawyer, but has this perception indirectly that he cannot even showcase, but still has that feeling that, ADR is coming to take away all this and this?
My message to them is one. They should probably be among, I would say, the promoters of ADR, in that they should try to see that it is well vulgarized. That is the language I would use probably. It is well grounded out there, so that the disputants or the litigants that would be potential litigants into the court will channel it and use it as an appropriate, by the way, instead of an alternative, as an appropriate. Then it will also be an added avenue to their livelihood in their business they'll be doing in that way. So they should try it in all this, and I'm very thankful that there are very many lawyers, actually. I would say
Who are
the list,
championing it?
yeah, the list that we have, 80% are lawyers, by the way. So you'd find the 20% from other fields, but 80% are lawyers. And even most of the mediations that are going through and are settling very well, in the background you'll find the lawyers that have really worked around the clock to try and see that the disputes are settled in that way. So there are many that are really, they are doing courses. Very many of them are doing courses. They are supporting it. So a few that still have that phobia around them, I'm telling them it's high time that they really take it up and embrace it, and let us make it professional. I've been traveling worldwide. I've traveled in several countries, and I've seen actually mediation elsewhere is giving a livelihood to people, and it's very expensive, by the way. Elsewhere, it is very expensive because mediators are paid hourly. Yes, are paid hourly in that way. So what we're saying, we haven't reached that way, and probably for us, we are mainly driven to give justice to our citizen.
Not yet,
not yet. But definitely we know
that's where it's
by and by. But even now, there are those that really are getting a livelihood from it in that way. So everything is it comes in motion step by step. So let us try to nurture it up.
I'm wondering, are there some incentives or policies that have been put in place so far to facilitate or to help lawyers, judges, prosecutors to embrace this mediation practice in Rwanda?
First of all, the first incentive is the trainings that are now given. Because these trainings, we are so lucky that we got the experts that are giving these trainings are world-class experts that elsewhere they will be costing a lot of money to attend their trainings. So we are so lucky that
get those trainings
we
for
get
free?
the training. So that is the first incentive that a person would get. Getting subsidized trainings that are subsidized, and the money that you could never get anywhere in the world elsewhere. I think that is the first incentive that we find. But the other incentive is that they would see how our country, our leadership is really providing all the necessary, I would say, avenues to try and enhance ADR. So that is also a mechanism. Recently, you've heard about the ADR center that was opened up in Nyamirambo.
Sure.
A very nice facility. all this is coming up for.
Actually, I was
yes,
going to
yes,
ask you about that. How are you planning to spread all these centers all over the country?
Yes.
Do you have a plan to have
very much
more?
so? Very much so. One, with our partners.
And how does that one of Nyamirambo actually works?
The one of Nyamirambo, the way it operates now, currently we have staff. We haven't, the structure of the managerial staff has not come into place, but we have staff that we pulled from one from the judiciary, from the Ministry of Justice, one from the prosecution, and we have partners from the Legal Aid Forum that are also sending us staff. That this staff came from these institutions. For now, they are running the center, and actually they're doing a very good job. By the way, if we get time and go and visit, you will see there's a tremendous work that is done there.
So
cases are
someone
being mediated there, and is doing very well.
So people take their cases there.
There are people that really reach out to them.
I wake up in the morning and say, you know what, I have an issue. I have an issue with
yes, and
A, B, C, D, and I feel like
reach out to them.
I feel like I want to reach out to them.
Or even cases, or even some cases that you've had that have already gone into the court. You can say we're already in the court, but we've decided, made up my mind, let's go for mediation, and you come to this staff that is at that center, and there's a facility. Mediation needs a place that facilitates mediation, of course. So that center was tailor-made for ADR, so it's doing very well. So these are also other incentives I was saying, that when you see facilities like this, when you see laws that the country is passing out that are really pro-ADR, when you see the policies that were passed, we have the criminal justice policy, the ADR policy that was passed by cabinet some years back. All that incentivizes you as a judicial officer, as a prosecutor, as a lawyer, that you are in a country that really is for ADR. But above all, when we have the rankings that come up and talking of us very well, and countries are coming to benchmark on us, I think that it makes us
proud.
Very proud. Recently,
sure.
we've been having a lot of judiciaries coming. We've had one from Namibia. Just yesterday, we had one from Lesotho. We had the Gambian with the CJ, the actor, they were at the center, and several of them, and several that are coming in here, and the reports that come out and show that we're really doing very well in ADR in that way. I would think, even if there's nothing else that could, but even only that would incentivize you as a person that is in this system to really be very much motivated to see what you can do in all in the circles you're in, to try and promote ADR. Because ADR is the future of providing justice, and it's doing, and we hope that definitely it will continue helping in helping the dispensation of justice in the future. Yes.
In some systems, and settings, people consider ADR as. I'm sorry to ask this, but I think let me ask it for maybe for someone out there. They consider it a poor man's justice. Some people call it poor man's justice.
No.
They say that it's quicker, but it's not fair.
No.
Would you give someone hope that if you go through this, you are really going to get a fair one?
Yes.
And how do you ensure a fair justice in mediation?
In mediation.
What is it that really... I don't know, maybe I think you understand what I'm saying.
Yes, I understand what we're coming from. First of all, people that have had a mentality that is a poor man's justice, not true. I've told you cases that are worth billion.
Yeah, I've heard them.
Worth billion. Is that little money?
No.
There's a time I was watching over a mediation that was being done some years back, and it was $1 million plus US that people were mediating over in the case. Is that little money?
It's a lot of money.
It's a lot of money. So that answers that this is not a poor man's justice. It is everyone's justice.
It's a person's willing.
Very
justice
much
is
so.
offered on your willing.
Very much so. And justice, every person is.
It's
equal.
like you give yourself justice.
Very much so. And that is what I was coming to answer the second question. But before that, I just wanted to let you know, to emphasize that every person is equal under the law. So we don't have favoritism. When you come in the courts, when you're before the law, there's no favoritism. You will not say this is rich or this is poor or this is what or this is. You see, everybody is taken as equal as the other. So that is justice. So secondly, as you said, fairness. In mediation, that is where fairness is attributed, because this is your will. No one will force you. Actually, that's why the mediator...
for sure. I like that.
Yes.
And I was really very scared about that because I was not sure whether the mediator does not intervene into the conversation. Because
no. Actually...
cannot be influenced. Can a decision not be influenced?
No way. And by the way, and that's the beauty of mediation. If you really have some fears and you say probably the mediator has been influenced,
you can choose someone else,
or you even have a right to walk out of mediation and say it's over, and they will definitely they will respect your
or
decision.
You can say now I want this.
Oh, definitely, and that's the two of you are the ones that will choose over a mediator, and that's why we give them a list and we say, "You look, we have a list. If you want private mediators, look on the list and you'll find a name and then choose over them." Or in the court setting, you would say, "I want this judge or I want this registrar," which doesn't happen in any other procedure. If it's in the court, the judge they've given you, you go with them. And them, they will rule according to what they've really grasped from your case. From your pleadings, from evidences, from the law, and then they rule. And that is, you will not intervene in anything. But here, it's you, the two. The mediator will only be a facilitator to reach a decision. So there can never be any bias, so I would say, by the way, that is the appropriate justice that you really do. Because you'll say, we are haggling over this, I bought this cup at probably 10,000. And so either you've broken it up and now I want my money, and you say, okay, but I didn't, it wasn't intentional. Can I give you 7? No, you say, no, but okay, go to 8. You see, it's not the facilitator will be saying, but you see, well, okay, this man also, it wasn't intentional, but, and you were friends, so why don't you say, okay, let's settle for 8,500. And you say, okay, it's fine. You shake hands and you're done and it's good. It's out of the willing, and even there, because a very good mediator will even try to bring you together. When we are angry and we couldn't see each other's, we will try to see that we can come together and now reach out and see each other, and then we mediate together. So it has a lot of beauty that it supersedes litigation in that aspect. So the aspect of saying there will be some bias, there will be some, no, it doesn't happen in this way, because it's your will. You're the one that chose me to be a mediator. If you find that I'm doing stuff that is not, you're free to walk out or to fire me and say, no, we don't need you anymore in our mediation. We want another person.
Is this person paid by the people seeking to be mediated?
Court judicial officers are not paid because we are government office. We are salary. We have salary.
Yeah, sure.
But private mediators,
if you choose a private
mediator, if you choose a private mediator, then you'll pay a fee. Yes, because.
But it is not somehow stipulated that this is the amount.
We have some fees that we stipulated that are, if you go on our website and you go and you'll find that there are some fees that but they're not so exorbitant. We've sent some minimal fees to try and facilitate the mediator. It's just a minimal fee that we find. We wanted it to start small so that by and by, when people get used, now they can offer fees that probably it's in reach of the parties in that way. But for the start, it's very minimal. It's there because a private mediator definitely will put in the effort, will probably use their fuel, will definitely will have spent some expenses. There are some expenses, so at least to cover those expenses, but they're not. But there are some cases which are out of the court where the mediators, where the parties will look for their own mediator, there they can agree on the amount of money that is not on our structure. So, and they're free to settle in one way or the other.
I want you to assure someone, if I heard you well, let's say I'm going through a conflict with a friend of mine, or maybe with a neighbor or with someone else, and I feel like I don't want to file a case, but I want to be mediated.
Yes.
Can I tomorrow ask the person I'm having conflict with that, am I the one to approach this person and say, please, I want us to be mediated. Can we join this center and be mediated? And can I walk to the center and ask them to request this person to come to the center for them to mediate us? Well, how does it go?
It's two ways. The first one is what you said. You can reach out to your friend or that person that you have a dispute with and say, look, I have an issue with you, but I feel I don't want to file a dispute with you. Let us go to someone that is neutral, that is at the center, or a mediator that I know that is going to help us solve this dispute. Or if you find it's very hard for you to reach out to your friend because either that person,
the conflict has gone high,
it escalated, and they can't look into your face and they don't want even anything to do with you, you can go to the center where you find the stuff and say, look, I don't, but I have this dispute, and I
feel I don't want to file a case.
So I want you guys to. So they will do what in mediation we call it convening. So they will help you with the convening stage or the process. So they will call your friend and say, look, they know how to go around with it. They're trained in that. So they know how to try and bring the disputant into convening, and then they will call them and then they'll begin the process in that way. So anyone that has disputes, worry not. Even those that are already in the court, worry not. Just go to the court and tell them, I've made up my mind. I don't want to go through litigation. I want mediation, and just let it to the judicial officers. They will figure out on how they will call the other party, on how they try to begin you in that way. So the rest, you just leave it to the experts. They will do it. When you begin, your first step is to say, I want this. The rest, just leave it to the experts. They will see how they can figure out on how you convene and start in that way. So that is the way to go. By the way, we've introduced in our system the ISMS, the Integrated Electronic Case Management System, the system that the litigants use to file their cases into the court. We've started an SMS notification that when you send a case in the court, you receive immediately a notification on your phone or any other gadget, notifying you that you have an option of using mediation in Kinyarwanda and in English.
Wow.
So like that. And people.
It's like a reminder.
It's a reminder. So you see how we've taken taken it very far.
Yeah, sure.
And actually, in the beginning, people were calling me and I was saying, because they find my name on the website, my number on the website, they say, "What is this? Is this genuine or is some scam that is?"
You're like, yeah.
I tell them this is very genuine. Don't worry about it. It's legalized.
If you feel like you want to do that, please go ahead.
Please go on, yes. There are two people that called me and said, even those that are started and they saw a registrar telling them, you've come into this session, you've come into the court, but there's mediation. So someone picked up a phone and called me and said, is this real? Isn't this court officer trying to scam us? And
how can a court advise us to go into mediation?
Yes, okay, this is scam. I told them, no, relax.
So it's like people were not used to this
very
easy way of handling
they know
cases.
When you go to,
they think like it has to be a hammer
very
thing.
Much so. Very much so. You battle the legal battling and all that and ends there. And they know things are now changing. There's another way also that you can get justice. And this is real justice also.
I really get
it's justice equal
so
to
much.
this other justice that you say. And by the way, it's good that you ask this. There are even people that wonder and think, how is a mediation agreement? Does it have same power or same force?
No, actually, that's the question I asked you, but you talked about little bit about it. But I really need to know how is this agreement goes?
Yes, if definitely you've mediated and settled, now you reduce your settlement into a settlement agreement. You will write it,
and it is signed on by the judge.
By the mediator who was if it's a judge, he will sign it. Because the judge was the mediator or the registrar. The mediator will sign it. The two parties, the real also sign on what you've agreed. And then it comes back into the court. If it was done out, it will brought into the court. And then the court will now make an order to enforce this agreement. And other legal, and
that order is executed by?
That order is executed but the way the judgments are executed, yes. So that order, when the order comes in, actually the order is very small. It says we are ordering the agreement that was reached by the two parties to be put in force. In other languages, it's called the Tomlin order. That is the name that is called that way. So we are ordering this to be executed. Period. They'll put on the enforcement, and then the rest is history.
So yes, as we head to the conclusion of our conversation,
yes,
I want us to talk a bit about high-profile cases. I was feeling like I wanted to ask you about. What is a high-profile case, and how do I know that? How do you know that this is a high-profile case? And for someone out there, they hear about high-profile cases. This is a high-profile case. Is it the media that hypes it?
That is media language. We don't have. As I told you, I think I told you when we were starting. Everybody is equal under the law. The law has no segregation. It doesn't have high profile or low profile, the rich or the poor. When you're under the law,
but you know, people talk about it out there. This is a high profile case.
No. That is. I think it's in the social media and all that will talk about high profile. But if you come into the court and you in the case, there's no high profile. You're all treated equally, and that is why you're all given all similar treatment when you're in the court. They will not say, and that's why when you come in the court, I don't know, have you seen a VIP area in the court? And they say,
there's no VIP.
This is VIP area, or this is VIP dock or VIP.
No.
Everybody's, if it's a dock, it's a dock. If it's a bench, it's a bench, and it's a bar, and all that is it. So, and it's good that you brought it. It's only that the cases are hyped, and probably because of reasons we really don't know, because we only see the cameras coming in, and people will probably be following this, and they don't follow the other case. But when we handle these cases equally, and we give everybody fair treatment. And by the way, that is why the law says the cases are judged as according to how they were filed in the court. So you will not say because this one is a VIP, then their cases were lodged yesterday, and then the next day they will have a date, and then the next day, no. They will wait for the date of the hearing like the rest that they came in. So there's no VIP, there's no preferential treatment in the court. Everybody is equal under the law, and this is constitutional.
Yeah.
Yes, this is a constitutional. So if it's anywhere that is happening in that way, that would be a violation of the Constitution. And as I said, the court officers are servants of the law. So we adhere strictly to the letter of the law as it is in the eyes of everybody. Yeah, in that way.
Judge Harrison, if you would conclude by telling us what does the future of ADL looks like for you in the future? I mean, in Rwanda, in times to come. What do you see in the future coming up?
Well,
what do you wish to see coming up?
What I wish to see it coming up, what I wish to see it coming up is, first of all, I have dreams that ADR in Rwanda, especially the ADR center now that we have, will be a hub of ADR in Africa. And that is my dream, that one day in our lifetime we'll see it happen. We have centers of ADR that are based in other regions, like in Asia, it's in Singapore. And why not in Africa? Could be Rwanda, and it can happen.
Sure.
Because we're doing a lot
We are known
around
for
that.
doing work.
The country has done a lot, has supported a lot in this. So we are very much optimistic that this will happen one time in our lifetime. And it's coming up, by the way. So that is what I anticipate in the future. But what I see and what I definitely look is that the future of ADR is very bright. Given that where we are right now, we haven't started a lot to be very vibrant in the execution of ADR and outdoing of ADR, but the moments that we've had, a lot has been done. That we've featured in very prominent forums. I will tell you that in Africa, only Rwanda is part of the. We have a network called the Judicial Dispute Resolution Network. It's for countries in the world that are prominently using ADR in their mechanism, and Rwanda is featuring in that network alone. I've been attending these networks virtually some years. No, even last year I attended the meeting was in Malaysia, and Rwanda was the only African country that was in, and
Really?
Very, very much so. And we presented what we are doing, and they were amazed. And we're with the other countries from Asia, from the United States, from Europe, and everywhere. This year they'll be meeting in the Philippines. That's where this network is going to be meeting. So that gives you an impression that the future is very bright. If even this we are in, where we've gone, we are recognized internationally, but also locally, we are doing a lot. I would say that the future is very bright. And my parting shot is that everyone that comes in contact with these mechanisms of ADR, they should try to, I would say, work towards taking them to another level. Not probably seeing them as something that they say is going probably to be a passing phase for only today and then they will, but try to see what can I do to see that ADR is enhanced, is taken to another level, and that the generations that come and they'll be following us, they find a ground that is very area that is footed in very firm grounds that it also could sail on and take it to another level for generations and generations. As I said, we are not reinventing the wheel. Reasons being that this is in our tradition. This has been in our culture, especially in Rwanda here. So it's something that we are very proud of, that we are now bringing back that our ancestors were doing. So we should be very much proud that at least we even bringing back the justice that was done by our ancestors, and we're bringing it back to be used together, side by side, alongside the classical justice. That is it.
When we started, you said you want to leave this place when you've said, or given people what you expected or wanted them to learn. What is it that you really think that you've left out that someone who is listening or who is watching this is supposed to get, that you think has not really got from this conversation, and you can tell it?
Well, the last thing that I probably have said it, but probably will be like re-emphasizing around it. What I've been said probably is that most people are still having a mindset of litigation in their minds. And we are seeing it that most litigants, their mindset is still fixated on litigation. That is, they still know that justice is only served when someone battles in the court and one will win and the one will lose. So my parting shot is that it's high time that we now change our mindset and say, we have litigation, yes, it will stay there, it definitely will stay and will be used in one way or the other, but we have also these mechanisms that have come that are also providing justice that is equal and the same, or even could be even much better than litigation in this way. And I just wanted to emphasize, I don't know if I emphasized it well, people to understand, if I say these mechanisms like mediation are providing better justice, is that I had never seen in the court where litigants, when I say litigants, these are people that have disputes. I had never seen them, I've never seen in court where litigants could reach a moment and hug and sit together and laugh and walk out and go to share a meal also. In my lifetime, the first time I saw litigants coming together in court premises or in court facilities, it's through mediation. And I can cite, it's only that we don't have time, but I could cite incidences where people said, we had spent 5 years down the line because of this dispute without shaking hands. And because of this mediation,
We've shook hands.
we have shaken hands in the court premises and they go away. I've seen, I know a case, there was a case in the East about divorce. And the couple had been granted divorce at the first instance, that is the primary court. And they appealed at the intermediate court. And this time when they appealed the intermediate court, they weren't appealing for divorce because it was done at the first instance in the primary court. Now here they were only battling around sharing property and the custody of the children, that is alimony and custody of the children. That is only what they want. But when they reached in the intermediate court, the judge who was presiding over it said, you people, all these, you have 4 kids. Why don't you give a second thought to this? And it took them through sessions. As I told you, it's an art. It's an art. You need how to see how you can bring them.
Cultivate people.
Very much so. And he did sessions and and you know what? These people got back together. Not, they said, actually, we no longer need a divorce. So recently, one of our colleagues was trying to really reaffirm this and called the number of the husband. And the lady picked and said, really, you're now together? And the wife said, no, if we weren't together, why would I be picking this? So we are together. So that is the beauty of mediation. You see
Definitely.
that? So just imagine
people who had already divorced.
Who divorced, but now, just imagine
custody
4 kids,
property
4
sharing.
kids. Now they were only going to be in suspense. They're going to be. And these are the repercussions of divorce and all this. And these kids will end up in street and all this. But now they were together and they were testifying. Actually, for them, they said use our case as evidence that the beauty of mediation and go and spread the word on us that we are now together. We are very happy. So I have numerous examples in business, in all settings and all that relation, leave alone this that we are working around backlogs. That is also very good because we want to hasten justice and give justice faster.
The beauty of people getting together after
social harmony, bringing back to people together who were not seeing each other. Just imagine someone who had a business and it's going to fall apart because of this, but now they are reunited, they're going back and they're doing business, and you know all this that is happening. So that is also something that is very important that I just wanted to stress. So everyone that feels you want this to go ahead, please join the movement that is supporting ADR and all this, and then we take it to another, and we know it is very beneficial. We have seen the benefit nationally and internationally, but we definitely see it in the future that the future is so bright around that. Thank you so much.
Thank you so much, Judge
Thank you for having me.
It's a pleasure to have you. We are
Pleasure.
very proud. We are happy.
Pleasure.
And thank you so much for teaching us, for educating us about everything about ADR and so many other things. For our viewers, we appreciate your time. We appreciate, the watching, the subscribing, the comments. We're happy about that. And please take time and watch this conversation. It's really wonderful, very educative, and you will share your comments later. See you next time. Bye for now. Oh, wow. What a wonderful conversation. Huh?
All right.
I've not
That is
had-
a bit. That is a bit.
I've
We
not
have a
had this
lot.
before. This
We
is
have a lot.
really wonderful. I
We
mean,
have a lot,
this
huh?
is this. Oh my goodness.
We have a lot.